Yes, please. Who appears for the claimants? Defendants?
Yes, my lord. May my lord be pleased. I am
Yes.
J.I. Ekoma.
J.I. Ekeoma.
Yes, my lord.
For the defendants?
Yes, I appear for all the defendants.
Defendants. Right. Is the claimant aware of today's date?
Yes, my lord.
All right. Defendants, are you ready to continue?
Yes, my lord, I am.
What is today's proceeding for?
My lord, the matter is slated today for adoption of final written address and judgment.
Okay.
Open that. Light.
Would you like to adopt? Sorry.
Yes, my lord.
Okay.
Open the window for please.
All right, please proceed.
As a couple, please. Lord, we have before your lordship our final written address dated 29th day of March 2022, but filed on the 7th day of April 2022.
Was it within time?
Yes, my lord. We filed within time, sir. Okay, so I'm so sorry, my lord. We filed out of time. We filed a motion for extension of time. And subject to the court's convenience and with the leave of this honorable court, may we humbly apply to move in terms. The motion was filed on the same date, 7th day of April, 2022.
All right, in the absence of any objection, it is hereby granted as prayed.
As the court pleases.
Yes, please.
My lord, the defendant's final written address was filed on the 7th day of April. And we most humbly adopt
Yes.
the said final written address.
Yes.
In support of our case.
Yes.
We therefore urge your lordship to dismiss the suit in its entirety.
Yes.
That's our humble submission, sir.
Now, did you come across the claimant's final address?
Yes, my lord. We were served with the claimant's final written address. My lord, with your kind permission, we also urge your lordship to deem same as having been adopted. It's dated 11th day of May.
That's 2022.
2022, yes, my lord.
11th May 2022.
Yes, my Lord.
All right. Is there any reply?
No, my Lord.
All right. Okay. Well, since there's nothing new, I have actually written the judgment and it is ready for delivery.
As a purposes.
So you may mute your microphones so that there will be no interruptions. Thank you. Now, by this, claimant's writ of complaint initially filed on the 11th of February 2019 against the defendants. She supposedly worked for them from the 7th of March 1988 until 2017, when she was allegedly dismissed from her employment. The centric issue contested in this suit by the claimant is the purported dismissal, which she believes to be unjust and unlawful. The defendants jointly defended this suit and sought to justify their action to be lawful. They also counterclaimed against the claimant's suits. The claimant's reliefs are set out in her writ, which I shall reproduce at the appropriate juncture in this judgment. Now, again, the claimant's complaint and accompanying processes were originally filed on the 11th of February 2019. But in her further amended statement of facts, she seeks the following reliefs thus. 1, a declaration of the Honorable Court that the dismissal of the claimant by the defendants is unjust, wrongful, and a breach of the contents of the letter of appointment. 2, an order of court directing the defendants to pay the claimants her 21 months' salaries from January 2017 to August 2018, amounting to the sum of 525,000 naira only at the rate of 25,000 naira per month, inclusive of the 1 month's salary in lieu of notice. And thirdly, the sum of 10 million naira being damages for the humiliation, emotional / psychological trauma, and the hardship suffered by the claimant. By the leave of this court, however, the claimant filed a reply and further statement on oath, along with an additional list of documents on the 3rd of May 2019. Although these processes were filed out of the period allowed by the rules of this court, they were accordingly regularized via the claimant's application for leave dated the 24th of April 2019, but filed on the 3rd of May 2019. Upon adopting her written depositions on oath in accordance with this court's rules, the claimant opened her case on the 17th of July 2020 by testifying and tendering a total of 7 documents in all, exhibits C1 to C7. She successfully closed her case on the same day, that is the 17th of July 2020. Meanwhile, the defendants filed their memorandum of appearance, statement of defense, and other accompanying processes on the 17th of March 2019. Although these processes were filed out of time, they were duly regularized via an application dated and filed on the 1st of April 2019. It is noteworthy that the defendants also filed a counterclaim against the claimant as follows. 1, 12,924,000 naira, the cost and value of various items equipment, and drinks vandalized, taken away, and stolen by the claimants from the hotel without the consent of the defendants stroke counterclaimants. 2, the sum of 20,880,000 naira, the amount realized by the claimant for hotel accommodation from January 2012 to December 2018, which she refused to account for to the defendants stroke counterclaimants. And 3, 5 million naira being the cost of this litigation. Eventually, and after several adjournments, the defendants opened and closed their case in one day. That was on the 22nd of February, 2022. They presented and relied on the testimonies of 2 witnesses, D1 being his HRM, Ezo Ukandu, and DW2 Jacob Nwadinobi Ndukwe. They tendered only 2 documents, exhibits D1 and D2 accordingly. At the conclusion of trial, the court granted the parties counsel leave to file their respective final written submissions. The defendant's counsel filed his final written submissions and arguments on the 7th of April, 2022, which was out of time, but duly regularized via an application filed the same date. The claimant's counsel, on the other hand, filed his final written arguments and submissions on the 11th of May, 2022, presumably within the allotted time frame. Unfortunately, because the Owerri division of the courts was formally indefinitely shut down on the 2nd of June, 2022, by order of the Honorable the President of this court, due to an unrelated crisis, proceedings in this case were interrupted until the 9th of January, 2023, when the court was reopened, and so the parties and their respective counsel were summoned by this court to appear today virtually in order to formally adopt their respective arguments and submissions, whereupon the court immediately made this pronouncement as its final judgment virtually, that is via Zoom. Please permit me to go to the decision part. You will be getting the judgment immediately after the proceedings today. Court's decision. Having gone through the entire processes filed in this suit, evaluated the evidence adduced by either side, considered the witnesses' testimonies, and analyzed the legal submissions of the respective counsel to these parties, I believe the issues for determination should be as follows. 1, whether the claimant is or was an employee of the defendants at all time material to this suit. 2, whether the claimants discharged the minimum standard of proof to be entitled to the reliefs sought by her in this suit. And thirdly, whether the defendants stroke counterclaimants have adduced credible evidence in proof of their counterclaims. From the evidence adduced by both parties in this suit, the first defendant is the chairman and managing director of the second and third defendants' establishments. It is also undoubtful that the second and third defendants are companies incorporated in Nigeria in accordance with the Companies and Allied Matters Act. However, these parties contest whether the second defendant exists to date. Although these defendants contend that the second defendant is inextant since 2007, it must be emphasized that since it is undisputed, the second defendant was incorporated and carried on business in Nigeria, it presupposes that any claim to the contrary, especially that the second defendant finally ceased to exist since 2007, must be proven and established by credible evidence. Now, it is of course trite law that he who asserts equally has the onus to prove such assertion. This is regarded as the evidential burden, which binds a party to prove the strings of facts asserted by him, which is distinct from the general burden of proof in civil suits. It goes without saying that the defendants bear the evidential burden of proving that the second defendant has in law ceased to be a statutory entity. This is especially so since the claimant tendered in evidence exhibit C2. That is the second defendant.
I am on the Zoom. I'm hearing the audio, but I can't accept the pictures.
Please switch off your mute your microphone, please. Mute your audio. Mute your audio. You're in court. Mute your audio. It's intercepting.
Yes, sir. Thank you, sir. So sorry.
Yes. If this piece of evidence is anything worth reckoning, it means invariably that the second defendant transacted business up to the said 28th of January 2011. To disprove this fact, the defendant will be required to bring cogent and direct evidence establishing the death or demise of the second defendant company before that date. As such, unless and until this is otherwise proven, I am not convinced that the second defendant is dead or inextant, as suggested by the defendants. An oral evidence concerning this is definitely insufficient of belief, since being a statutory entity, its death must also be communicated or announced to the entire world, quite similar to an obituary for a natural entity. The second defendant, even if it is believed that it no longer carries on business as a registered trading company, has not been proven satisfactorily to be dead, and I so hold. Therefore, for all the intents and purposes of these suits, the name of the second defendant cannot be stricken off this court's records. It is thus declared to be jointly and or severally liable to any claims which may flow or arise from this suit against it. On the premise of the foregone, this court shall now consider other pieces of evidence before it in determining the current issue number 1, which is still being evaluated and presently under consideration. Recall that the claimant tendered exhibit C1, which is the letter of appointment dated the 7th of March 1988 for the terms of the said exhibit C1 were breached by the defendants in their purported dismissal of a contract of employment. Perhaps it may be in the interest of continuing legal education to state here that the decision of the English court in Salomon versus Salomon, citations provided, is a holistic legal vestige from which many modern legal advancements in the corporate world are traceable. Today, it is well appreciated that the company is not a subject of a chosen action or chosen possession, and consequently is incapable of being owned. Some individual members of a company may own majority of the company's dividends or shares and resultantly possess special voting rights, which still does not translate to the physical ownership of the company in the real sense of the expression. Being a creation of law, therefore, a company can only act through natural persons who make up the company, to which the directors, managers, secretary, members, agents, etc. Whereas the directors or managers are presumed to be the central and controlling minds of the company, the employees, servants, and or other persons or agents of the company are referred to as the organs of the company carrying out the directives of the center. Thus, a company shall be liable for its own actions, whether civil or criminal, except in some exceptional situations where the doctrine of lifting the veil may be invoked by the court in the interest of justice. This includes where directors, managers, other agents, and or servants of a company should share criminal liabilities with a company. And in such circumstances, such officer will bear the liability alone for actions resulting in any crime taught, even while carrying out his official responsibilities for or on behalf of the company. I find as a fact in the instant suit that the second defendant, Okandu Motors Nigeria Limited, is a separate legal person existing independently from the third defendant, Starlink Global Hotel Nigeria Limited. I read and refer to paragraph 5 of the written statement on oath of the CW1, where it is stated thus, and I quote, "The defendant's business from 1988 was in the main on car accessories and services, and when the business dwindled, the defendants ventured into the hotel business, and they established a third defendant at Ogbo Hill, Aba, called Starlink Global Hotels Limited, and they transferred the claimant to the hotel, first as a cashier and later promoted as the hotel manager in July 2012. Now, the inalienable inference from the above excerpt is that the second defendant company had business troubles at some point during her service to the company. And so this claimant subsequently began working with the third defendant hotel. What is, however, not clear is why the claimant preferred to refer to the first, second, and third defendants in unified terms, which also begs the question why she elected to sue these three defendants jointly and severally in the first place. It must be emphasized without mincing words that the claimant was not employed as an employee of the first defendant for the mere fact that she was employed by the second defendant company, although the first defendant is a director and chairman of the said second defendant company. Similarly, the claimant's employment in the second defendant company does not automatically become an employment in the third defendant entity without other cogent evidence to establish this. Of course, the claimant has the onus to establish the existence and nature of a contract of employment at all times, and it has consistently been held by this court as well as the appellate courts that the best way to so do is by the production of a contract of employment where one exists. You may see the recent Supreme Court case of Charles Olushola Toyimbo versus Union Bank PLC, 2023, 1 Nigerian Weekly Law Reports, part 1865, 403, at page 403. Unfortunately, this claimant has not shown or established by any credible and satisfactory evidence that these second and third defendants are subsidiaries of a parent company or a group of companies. Thus, the allusion by her that she was an employee of the first, second, and third defendants at all times prior to this suit, in virtue of her employment by the second defendant company, is untenable and I must hold. Despite so, the correlative question is whether the claimant was under the employment of the third defendant at the material time preceding this suit. The first defendant, that is BW1, stated in paragraphs 9 and 10 of his written statement on oath as follows, and I quote 9, that in 2012, 3 years after the hotel was established, the claimant approached the first defendant and pleaded with him to give her a place in the hotel to enable her be busy than staying at home and be able to take care of her responsibilities. Having worked with the first defendant in the past, the latter was obliged to give her a place as a typist or cashier in a hotel. 10. That the defendants will contend that no letter of employment was given to the claimant regarding her appointment with the third defendant. End of quote. What I deduce from the above depositions is an attempt to characterize the claimant as a non-employee of the third defendant. This contention is simply a non-starter, especially in consideration of all the credible evidence before this court, which amounts to an admission of the existence of an employment relationship. For instance, the first defendant stated further in paragraph 12 of the same statement on oath that he was quite content and comfortable with leaving the management of the third defendant establishment solely in the hands of the claimant sometime in 2015 until the issue that led to this suit arose. It is inescapable for the testimonies and evidence of the CW1 and DW1, both on paper and in open courts, that the claimant worked for the third defendant establishment for money consideration by way of salary. Now, although the claimant could not tender any letter of employment from the third defendant, the admissions by the defense witnesses, especially DW1, that the claimant was not issued any letter of employment is reason enough for him not to be exculpated from his duty as an employer to issue a letter of employment to a worker. In the instant case, therefore, it is a failure on the part of the third defendant establishment not to have issued this claimant with a letter of employment in virtue of section 71A to H of the Labor Act 2004. An employer is under an obligation to give a worker a written statement not later than 3 months after the commencement of the worker's period of employment, stating the name of the employer, the nature of the employment, the rates of wages, and the method of calculating same, the appropriate period of notice to be given by the party wishing to terminate the contract, etc. By section 21(1)(c) of the same Labor Act, an employer shall be liable on conviction to a fine not exceeding 800 naira for contravening the provisions of section 7. In any event, the failure on the part of this third defendant to provide a letter of employment to the claimant in line with the extant laws does not dislodge the fact that the claimant was his employee for the duration she accordingly served in the third defendant company. Therefore, in resolving this issue, the claimant, for all intents and purposes, is an employee of the third defendant at all times material to this suit, and I so hold. On issue number 2 for determination, which is whether the claimant discharged the minimum standard of proof to be entitled to the relief of this suit, this court shall attempt to resolve this issue on the framework of the reliefs ultimately sought by the claimants. Relief number 1 seeks a declaration that the dismissal of the claimant by the defendants is unjust, wrongful, and a breach of the contents of the letter of appointment. From my facts finding, it is manifest that the claimant was dismissed. Excuse me. Now, from my facts finding, it is manifest that the claimant was dismissed from her employment with the third defendants. The only gray area to ascertain is what was the justification for her dismissal. The defendants contend that the claimant was dismissed for alleged mismanagement of the business funds of the third defendant hotel. It is equally alleged that she is responsible for vandalizing some hotel properties belonging to the third defendant. This is captured in the second arm of paragraph 20 of DW1 statement on oath, which states thus, and I quote, "Besides, the first defendant is entitled to dismiss the claimant for gross misconduct and abuse of her office, as she did by squandering the monies belonging to the hotel third defendant, refusing to render an account, and vandalizing and selling of the hotel property. End of quote. Now, dismissal is a stiffer disciplinary measure that disentitles an employee to any entitlements from the employer. And a dismissal is also preferred in most extreme cases of misconduct. It is right that what amounts to a misconduct is a question of fact, and there is no fixed rule of law defining what degree of misconduct will justify a dismissal. It is enough that the conduct of a servant is of a grave and weighty character or nature as to undermine the confidence which should exist between him and his master. The DW1 had maintained both in his statement on oath and under cross-examination that the claimant mismanaged the business fortunes of the third defendant. In his exact words under cross-examination, he stated as follows, and I quote, "When I was sick and old, I asked her to manage the hotel. She destroyed the hotel and stole about 30 million naira away." End of quote. Still under cross-examination, the claimant's counsel elicited the following response from the DW1. Question: You did not demand for the inventory of the hotel when you were sacked as the claimant. Sorry. Question: You did not demand for the inventory of the hotel when you sacked the claimant. Answer: I did, but she refused to give me any accounts. I am also aware of Exhibit D1, the 10th September 2018 appeal for leniency letter, which was tendered by the defendants without objection from the claimants. Let me quote what she wrote in paragraph 2 of that letter of appeal for leniency. And I quote, "Your Majesty, I am not taking advantage of my long period of service to you, nor canvassing it as a license for mischief. But I assure you that the whole thing emanated from my mistake of not being timely enough in telling you when things went wrong at the business sites. I was afraid of you and trying to avoid anything that affects you or upsets you, given the level of reverence I nurture for you." End of quote. According to DW1, the claimant wrote the said Exhibit D1 seeking his pardon for her alleged mismanagement of the third defendant's hotel. The same evidence is meant to convince this court that the claimant admitted responsibility for the mismanagement of the funds of the hotel. In the 4th paragraph of Exhibit D1, the claimant wrote the following, I quote, "You know I am a woman, never attended any higher institution for me to take my certificate and start looking for a job elsewhere. This is the reason why I am still pleading with you to forgive me for this mistake I made. I managed any of your properties in my custody, including Starling Global Hotels Limited, as mine because of the long-standing relationship between you and I. I am also attracted to paragraph 6 of the letter, which reads as follows, quote, "Note, all my effort was to see that our hotel moves on smoothly. I am sure that the people who made away with all these things are still out there." End of quote. On the strength of the foregoing and from uncontroverted evidence before this court, I am quite convinced that the defendants successfully established sufficient justification for relieving the claimant of her employment. It is apparent she committed an act or neglected in acting appropriately to thwart the commission of acts by third parties while being in charge of the affairs of the hotel. and same may be described to be of a grave and weighty nature while discharging her functions as the manager of the third defendant establishment, thus undermining the confidence which should exist between her and the third defendant. The relationship being entirely master-servant in nature, it seems that her dismissal was a consequential, direct, and warranted disciplinary measure on her by the third defendant for failing to, as the defendants put it, properly manage the hotel's business funds and assets as a manager of that establishment. And I so hold. Consequently, I am reasonably satisfied that the defendants were justified to have dismissed the claimant based on the available facts before this court, which are corroborated by the contents of Exhibit D1. The claimant's relief 2 seeks for an order of this court directing the defendants to pay her 21 months' salary from January 2017 to August 2018 at the rate of 25,000 naira per month, totaling 525,000 naira. The claimant also seeks a month's salary in lieu of notice. The law, given the new dimension of employment adjudication, especially in Nigeria, is that whether termination or dismissal is wrong or not, all earnings of an employee prior to the dismissal must be paid by the employer to an employee. Now, you may see the judgments of the Supreme Court in Charles Olushola Toyimbo versus Unity Bank, Supra. However, I simply cannot dismiss or ignore the statement made by the defendants that as the manager of the third defendant's hotel, the claimant was actually in charge of payment of the workers' salaries as well as hers. As such, how she have ignored or neglected herself salaries for the periods she was the de facto manager of the third defendant hotel? Interestingly, the claimant never rebutted this claim, and same shall be taken as an admission in the absence of any contrary evidence. It must be remarked that the claimant stated in her evidence in chief that she was promoted to the position of the manager of the third defendant in 2012, although the defendants put the date as 2015. Be that as it may, the fact that the claimant was the manager of the third defendant at the material time, that is from 2017 to 2018, when the alleged debts accumulated and the mismanagement of funds and assets occurred, is clear and unequivocal. Besides, the claimant has not put forward any facts or supportive evidence to establish the mode of payment of her salaries by the third defendant, or any proof that she was indeed paid by a third party and not by herself, contrary to what the defendants contend. In any event, there is a dearth of evidence to the contrary that the claimant paid herself during the period in question, and it does not accord with common sense and reason that she could have afforded to owe her own self for that period or for those periods. This court is not swayed to accept an incredulity, which is in fact the claimant's sole duty to venerate. Therefore, the claim by the claimant that she is owed arrears of salaries by the defendants for the periods claimed is far from being proven, and I so hold. Relief number 2 shall not be granted. I mentioned earlier in this judgment that the claimant also claimed 1 month's salary in lieu of notice under the same relief number 2 under consideration. This claim has become academic as it has already been determined under issue number 1 in this judgment. In effect, the claimant was duly dismissed, and so she is not entitled to any notice or to any salary in lieu of such notice, since her employment was not terminated but dismissed. There can be no compensation for a lawful and justifiable dismissal of the claimant's employment. Automatically also, the claimant's relief number 3, which seeks for the sum of 10 million naira as damages, for the humiliation, emotional stroke psychological trauma, and for hardship suffered by the claimant also fail, and same is hereby disallowed and dismissed accordingly. Without ado, this court is not inclined to award any unwarranted general or special damages to the claimant. In all, issue number 2 is accordingly resolved against the claimant and in favor of the defendants. Now, on issue number 3, this issue seeks to determine whether the defendants stroke counterclaimants have adduced credible evidence in proof of their counterclaim. The defendants had in their statement of defense made certain counterclaims against the claimant as follows. 1, 12,924,000 naira, being the cost and value of various items, equipment, and drinks vandalized, taken away, and stolen by the claimant from the hotel without the consent of the defendants or counterclaimants. 2, 20,880,000 naira, being the amount realized by the claimant for hotel accommodation from January 2012 to December 2018, which she refused to account for the defendants or counterclaimants. 3, 5 million naira being cost of this litigation. The defendants or counterclaimant tendered and relied on Exhibit D2, an inventory of missing properties in the third defendant's hotel. This document has 23 pages in all. The first 22 is an elaborate list of various items and their supposed market value, which total 12,924,000 naira. There is also paragraph 23, which shows the calculation of a supposed unaccounted earnings of the third defendant counterclaimant. The said paragraph 23 read as follows, I quote, that she, the defendant to the counterclaim, should make account of 2 years' money realized from the hotel from July 2016 to June 2018, which is an average of 3,000 naira per room for at least 7 rooms per day, totaling 21,000 naira, and rest time for at least 8 rooms, which is 8,000 naira per day, which is 29,000 naira per day, multiplied by 30 days, which is 870,000 naira. Therefore, 874,000 naira times 24 months, total is 20,880,000 naira. The first defendant counterclaimant stated in paragraph 14 of this statement on oath, of his statement of oath, that he, that is the DW1, discovered that various properties of the third defendant counterclaimant as contained in Exhibit D2 were vandalized and or stolen. These allegations made in the form of counterclaims are criminal in nature, and the law is tried that as seen in section 135 of the Evidence Act, that if the commission of a crime by a party to any proceeding is directly in issue in any proceeding, civil or criminal, it must be proved beyond reasonable doubt. It is imperative to ask, have the defendants stroke counterclaimants proven their counterclaims based on allegations of vandalism and stealing beyond reasonable doubt against the claimants stroke cross-defendant? In answering this, I came easily to the realization that the defendants stroke counterclaimants have not shown that there was an actual allegation of crime against the claimant stroke counter-defendant. First, there is no formal proof of any complaints to the police or other security agencies concerning these allegations. It is irrelevant if any report to the police was allegedly withdrawn by the defendant. Secondly, the inventory relied on by the counterclaimants was made by the first defendant stroke counterclaimant, and no formal investigation report is shown to back him up. I am not unmindful of the second stratum of the counterclaims, which borders on accounting. The counterclaimant claimed a sum of 20,880,000 naira under that head alone. A cursory look at paragraph 9 of the defendant's joint statement of defense indicates that according to the counterclaimants, these claimants took over the managerial position of the third defendant in 2015. However, what I find baffling is that the defendants stroke counterclaimants stated in paragraph 13 of their statement of defense that in paragraph 16 of the DW1 statement on oath, and in paragraph 16 of the DW1 statement on oath, that is the same 20,880,000 naira is the amount realized by the claimant in the third defendant hotel from 2017 to 2018. Again, in paragraph 21B of their counterclaim, as one of their reliefs, the defendant's counterclaimant stated that the same 20,880,000 naira is the sum realized by the claimant from 2012 to 2018. These inconsistencies do not just end there, as the defendant's counterclaimants again produce Exhibit D2, where it is clearly stated that the same 20,880,000 naira was realized by the claimant from 2016 to 2018. These obvious conflicting facts scream loudly to the high heavens of how unreliable they are to sustain their cross-action against the claimant. They are thus not only unsafe, but unreliable to ground the cross-claims. In any event, the defendants to these counterclaimants, or to these counterclaims, that is the claimant, stated in an evidence in chief that the first defendant was always collecting the money realized from the business in the third defendant. DW1 maintained that she managed the third defendant hotel together and with the supervision of the first defendant. However, the first defendant, that is DW1, stated in paragraph 12 of his statement on oath that the first defendant left the management of the third defendant solely in the hands of the claimants stroke defendant since 2015. It is notable that under cross-examination, DW1, that is the first defendant, stated that he is no longer the managing director of the second defendant, that he is still of third defendants. There is, however, an obvious contortion of the truth because in Exhibit C4, an exercise book titled Short Time Book, Manager Stroke CMD Record, it is clear from the entries seen in folio 22 that up to 6th November 2016, and even in the year 2017, as can be seen in subsequent folios, there are records of monies, perhaps incomes, and at the end of each day's record, an endorsement collected by CMD followed by an amount and a signature. Unless it is a masked attempt by the defendants to hide their fortunes from the relevant tax authorities, this is incontrovertible evidence that the first defendant had been involved in running and managing the business of the third defendant jointly with the claimants of defendants. Besides, the defendants never challenged the evidence in Exhibit C4, so this is presumably an admission of the facts and inferences elicited therefrom. It is thus safe for this court to assume that the facts contained in this piece of evidence are fully admitted by the defendants to counterclaimants and same need no further proof of. Now, these facts actually whittle down the evidential value of Exhibit D2. Exhibit D2 lacks the evidential credence to be attributed full weight in this suit as proof that the claimant managed the third defendant alone and failed to account for all the monies realized therein from 2012 to 2018 or any other time. In the absence of any credible evidence to substantiate their counterclaims, therefore, these counterclaims lack any merit, and I so hold. Issue 3 is resolved against the counterclaimants in favor of the claimant defendants. Now, for the avoidance of any doubt, therefore, this court hereby dismisses both the claimant's case as well as these defendants' counterclaims. Parties shall bear their respective costs. That's my judgment.
Ask all places.
As a court pleases.
Ask all places.
Thank you.
As a court
J.I. Ekoma, right?
Yes, my Lord.
Did you handle this matter from the beginning?
Yes, my Lord.
All right.
Thank you very much for the well-considered judgment, sir. We appreciate.
Well, you'll get a copy of it online in the next few minutes.
As a court pleases. We're very grateful, sir.
Thank you. What is the name of the council that?
My Lord, Prince Okechukwu is my name.
Prince Okechukwu.
Yes, my Lord. I've been online. Only that I could not see you visually.
Okay, maybe you check you switched off
Lord,
your
I want
video.
to thank you very much for that is a judgment that was brought by Daniel. It's an erudite one. I've learned much from it. I'm satisfied by your judgment. God bless you, sir.
Thank you, sir. I wish you all the best as well.
Thank you, sir.
Thank you. So Chris Okechukwu.
Prince.
Prince,
P-R-I. Yes, sir. Prince Okechukwu. Prince Okechukwu. P-R-I-C-E.
Yes, please. So you will get a copy of the judgment from the Owerri division, perhaps in the next 24 hours or 48 hours. But you read it online in the next few minutes.
We are grateful, sir. Most
Thank
grateful.
you. Thank you.
Thank you very much, sir.
And keep you for us, sir.
Thank you. Any other application?
No, my Lord.
No, sir.
All right. So I wish you all the best.
Thank you so much, sir.
Good luck in your endeavor.
Thank you. All right. Thank my little friend, Koma.
Okay. All right. He's watching you, I guess.
Thank you, Mr. Okechukwu. I appreciate it.
The court will rise.
Court.